I'm Barnaby and we'll welcome you to our take with the panel on the Economic Crime and Corporate Transparency Bill, particularly freezing and forfeiture of crypto assets. I wanted to call it, is it the bill which sorts out the dark web and takes all the cryptocurrency assets and sorts out money laundering? But I thought that wasn't as quick and punchy as the one we came up with. On my left is Andrew Boden-Brown. He is a partner at Shoosmiths, specialising in banking and finance litigation, asset-based lending and alternative finance lending, particularly with a crypto asset recovery specialism. He's on the crypto working group for Shoosmiths and will be talking us through the definitions of crypto assets as his specialism. Then next to me is Lauren Bowkett. Have I pronounced that right?
Close enough.
I managed to try not to. She's a principal associate at Shoosmiths, specialising in fraud and financial crime, matters with, as you all know, a specialisation in confiscation and asset recovery. To my right is Gemma from Brighton Andrews Hill. She's a wonderful POCA specialist and also deals with high-level crime as well. We are going to go through the Act and the proposals as they stand at the moment. What we are looking at doing is setting out what the bill has in it at the moment. It's currently at the House of Lords stage, committee stage, and is estimated to be passed into law. We expect later in 2023, but there is a lot of issues which are going on and a lot of other legislation, as you've heard in the press today, which might be passed. There is a lot of parts of this bill, but we're focusing on Schedule 7. And what we see there is a way to combat crypto assets and the use of crypto assets as a mechanism for crime. So how they are laundered, how money is laundered using them. The law that has been used to adapt is an adaptation of both cash and account freezing provisions. And how we have broken this down is that Andrew will talk about the different definitions. We'll then look at the different types of searches which are allowed under the Act and freezing provisions under the Act. And Lauren will go through those. And then we'll talk about the forfeiture stage. And Gemma will deal with that. And then we'll round up and have a conversation about the different issues, the possible pitfalls, and also answer any questions which arise. If we could just go to the next slide, Tess. What I hope to do is also discuss, and these will be a point of questions, where we might see changes in the legislation after it comes through the committee stage of the House of Lords. Especially at the moment, we're seeing quite a lot of legislation is questioned at the committee stage of the House of Lords because of the specialists who are there, and we might see an expansion. I expect to be sort of more expansion on the forfeiture provisions and the freezing provisions. We also discussed with Andrew the definitions of fit for purpose and how this will mesh with the current case law. Without trying to spoil it, it will mesh well because they've taken the account freezing provisions and the cash provisions and applied them to this area. That doesn't mean it will be a perfect fit, but these are tried and tested mechanisms going back 40 years, in some cases with the cash provisions, and have been dealt with in a variety of different jurisdictions. Next slide, please. So, what does the provisions do at the moment? It allows for the search of the premises and locations to find crypto assets and information related to crypto assets. It then allows the seizure of crypto assets, crypto asset related items, and crypto wallets. So it allows anything which might hold information related to, or the assets themselves, allows that seizure and then an investigation to take place, which can last up to 3 years, which is a move away of other legislation. It then allows the crypto assets to be converted potentially, waiting for a final hearing. There's, as in with AFOs and account freezing orders, there is the allowance of exclusions for legal expenses and living expenses. And there's also provision for releasing crypto assets to victims. That's a move we're seeing with AFOs. There's another amendment to the account freezing orders going through in this bill. And it is an attempt to get assets to victims. As you might know with account freezing orders, that's not possible on the face of the legislation. Though, as I did last week, you can vary an order under Section 303Z4 to give money out of account freezing orders to victims. But this is formalising that arrangement. And there is the allowance of sale or destruction of any item which is seized in this process. So, go to the next slide. If we just, this outlines where those different provisions are. As we're going to go through them, I'm not going to go into any detail. But let's start off by talking through the definitions. Next slide. So first, Andrew, the definition of crypto assets. Does that cover everything you would expect it to?
It does. The biggest issue we've got here is that in all circumstances, the technology, of course, advances quicker than the law. So by the time it's been put on the statute books, the advancements that we are seeing in the technological age that we're at the moment means that things are developing and changing on a regular basis. But it's a definition that has been tried and tested. It's been in place for some time. Obviously, the Crypto Task Force used this particular definition in March 2018. And of course, it forms the basis of the approach taken in the money laundering and terrorist financing regulations at the moment. So it seems to cover the vast majority of what is needed.
And when you were talking about technology, could you just give an example of how quickly the technology is moving in this area?
So new coins, new tokens are being created all the time. My 12-year-old probably knows more about NFTs and crypto assets than most people. It's a technology that is changing on such a regular basis. We have small armies of people creating and developing new systems, new applications on a regular basis.
But this definition seems to be wide enough to cover that?
It seems to be wide enough for the moment. There's always, as I say, with technological advancements, issues that will potentially arise. What we do have is a judiciary that seem to be flexible enough to apply it to what we need in the current circumstances.
Is that what you're seeing in the civil areas?
Yes. So one of the solicitors in my team, solicitor called Matthew Green, was involved in the AA Persons Unknown re-Bitcoin case in 2019, which decided obviously that crypto was property. Since then, it's been referred to on numerous occasions, and we've seen a number of advancements led by the judiciary to allow service of proceedings by NFTs, for example. So that there is flexibility within the system. What we hope is that the judiciary continue to keep a pace and keep abreast with the developments, so that as and when we need to call on them for various nuance issues, they're as adaptable as we need them to be.
I imagine that having this area brought in, where there will be quite a lot of judicial scrutiny, as we're expecting quite a few cases, will mean that the judiciary have to keep a base of that. And the more cryptocurrency cases they see, the more knowledge they'll have.
Absolutely. It's not the case, unfortunately, that every judge that we've been before is fully cognizant of exactly the particular the nuances of what we're dealing with. But the vast majority have adapted. The vast majority are keen to learn. I have engaged with a number of external parties who have been approached by members of the judiciary to assist to help with the understanding. But of course, as I say, the technology adapts and changes so quick. To be honest with you, it's very difficult for everyone to keep up with it. We are adapting at the same time as judiciary.
Yes. Well, now let's just go to the next slide and discuss crypto wallets. So how would you describe a crypto wallet?
So a crypto wallet is a device where you are able to store cryptographic public and private keys. There are, I suppose, different forms, and many people may be familiar with the terms hot and cold wallets. For those who don't know or don't understand the difference, a hot wallet is generally something that's online, relies upon software for access and use. So an example of a hot wallet is something, say, for example, you are holding all of your information with a provider such as Coinbase, a MetaMask, or a Binance. A cold wallet is something that is kept offline. So internet connectivity is the biggest differentiating factor. One of the biggest issues that we have found in the civil space, and a number of the cases that I've been involved with have potentially involved, for example, insolvency practitioners, trying to identify what they're looking for. An insolvency practitioner is used to walking into a business and looking for the books and records, for example. They're looking for the accounting information. What they're not necessarily looking for is 12 random words written on a piece of paper, or a device that is no bigger than a thumb that looks like a USB device, which of course could be a USB stick, or could be a cold storage device. What they're also potentially not looking for when they're entering commercial premises is scraping the website to find out if the business has ever received or dealt in crypto. So one of the things that we're encouraging people to do is look at the bank accounts. Can you see fiat currency going into a Binance, a MetaMask? Names that don't seem to be overtly familiar require an extra degree of interrogation. But in terms of looking for the public keys and the private keys, a lot of our investigations are focused around what we can do to try and find those. Without them, unfortunately, things become very difficult.
It's very interesting you mentioned they're looking for different codes. One of the first cases I ever dealt with on cryptocurrency was back in 2015, where a trainee walked in with a very experienced financial investigator, saw something, he had almost thrown it away. It was actually a passcode to a wallet, and they netted, it was about 5 million.
Yeah.
And it's exactly that. And I think you're right, whereas training is going to be a large part of supporting this.
Agreed. And looking for these things as a priority, as opposed to we've looked for everything that we would usually look for, and therefore let's send someone in now. These devices are small enough, if it's a cold storage device, are small enough to be taken in a pocket, to be put in a bag. These things can disappear on a regular basis. I deal with a lot of fraud-related matters, and we caught someone trying to extract Word documents on a memory stick in a camera. So, the technology is that sophisticated that it is difficult to find, but it's generally the case of looking for it at the outset. It is one of the assets. And of course, as we know, obviously the market is slightly different at the moment, but in a boom market, the value of these assets could potentially exceed everything else in the building very, very quickly.
Yes. Well, we've seen in other spheres, fridges being used to hide technologies. So you can see that it is that broad.
Yeah, it's fast-paced, and it requires people to have an understanding of what they're looking for. Unfortunately, it isn't the case of you just send in a generic team of investigators and you're going to find everything. It is a case now that we are having to become more specialist, and therefore on some of the investigations that we look at, you need IT specialists to be walking in, looking for these things, trying to find devices that either are connected or have been removed from the internet.
So let's just go to the next slide and look at crypto assets exchange. Again, can you just talk us through what a crypto asset exchange provider is?
No problem at all. So crypto asset exchange providers are effectively firms which exchange, arrange, or make arrangements, and that's whether automated or otherwise for the exchange of money. So we're looking here at fiat currency, converting that into some kind of crypto asset, or converting one type of crypto asset for another. So generally what we're looking at here is a catch-all term to describe both crypto exchanges and custodian wallet providers. So again, a Binance, a Coinbase, and MetaMask would be a kind of a good example.
Is there anything in that definition which you think is a problem, or is that a definition which it seems pretty standard?
It's been taken from money laundering regulations. It is pretty standard. The biggest issue that we tend to find with the crypto asset exchanges, let's just say that they can be jurisdictionally ambiguous as to where they are based. So trying to serve proceedings on any of the exchanges can prove very, very difficult, to the extent that very often they're in jurisdictions that aren't particularly helpful when it comes to service. Trying to find contact information can be very, very difficult. But fortunately, we've been dealing with a number of exchanges now for some time. We tend to have good relationships with a variety of different exchange providers. But for a lay person, it is fantastically difficult to try and make communications at the right level.
I imagine, and it is a smaller problem, but it's same type of problem with account freezing orders. But I imagine this is going to be a very big issue. Also, the jurisdiction issue, whether it is within the jurisdiction, might be a point. And we'll circle back to that at the end. Let's just go on to the next slide, slide 9, last of the definitions. Custodian wallet provider. That links in with the hot and cold wallets.
It does. So these are firms that provide services to safeguard and administer crypto assets or private keys. So what we see is wallets can be custodial or non-custodial. With non-custodial wallets, the individual has the sole control of the private keys. With custodial wallets, you're effectively giving control to a third party. Some of the crypto asset exchanges provide non-custodial wallets. So say, for example, there's a Coinbase wallet or Binance custody, which allows you effectively almost the best of both worlds. You're providing the information to a third party, but it is held by you. But control, as we've seen in some of the recent, I suppose, insolvencies, FTX, for an example, lots of people unfortunately found out very quickly that they didn't control the thing that they thought they controlled. So a lot of our time has been taken up looking at the terms and conditions of the relevant exchanges. And it's genuinely terrifying having conversations with people that thought they understood what they had investigated or invested in, to find out that they have release control and don't have control over the assets that they thought they had.
Well, that's going to be very interesting with how this actually works, of how much control people have and how much control law enforcement can have over these assets and have over the third parties. But we'll go back to that, because that's going to be quite an interesting topic. Let's go on to the next slide, and then going into the meat of the legislation of how it operates. Searches. So Lauren, what is the role of searches and how are they operating in this legislation?
Yeah, so my plan here is to take a deep dive into the searches and application available under the new bill. So in terms of the searches, these powers, they have been introduced under Schedule 7 of the bill, and these are all amendments to Part 5 of POCA. So it makes provision for a civil recovery scheme in relation to crypto assets, but previously there wasn't one at all. So if we just take the first section there in terms of searches, it allows for search if lawfully on premises, or if the officer has reasonable grounds of suspecting that there is a crypto asset related item on the premises. So to break that down for everyone, a crypto asset related item is obviously a new class of seizable property. It's something which hasn't been established previously. We've previously had a little look at crypto asset related items, and it's an item of property that is or that contains or gives access to information likely to assist in the seizure of recoverable property or intended for use in unlawful conduct. Property in this circumstance is that or contains or gives access to information that is likely to assist in the seizure of any crypto assets. And harking back really to what Andy said previously, we're talking about things here such as tiny pieces of paper with 10 words on them. We're talking about seed phrases here, hardware wallets, laptops, mobile phones, tablets, computers with any relevant information on it, or gives us control of a software crypto asset wallet. So, for instance, a phone with an app on it which gives you access to that wallet. There must be suspicion that it is a recoverable property or intended for use. And what we mean by suspicion here is, as per the drafting of the bill, reasonable grounds for suspecting that there is a crypto asset related item on the premises. This particular section in relation to searches is split into three. So it looks at the premises. It also makes provision for searches of vehicles and also searches of the person.
So going to the next slide.
I'm glad you had no questions for me there.
Because I like the term seed. What was it?
A seed phrase.
I like a seed phrase.
Okay.
But I think we've covered that in the issue in relation to difficulties of knowing what happens.
Absolutely.
I'll try and have a zinger later.
Please don't. Okay, so moving on to the next slide here. We're talking here about seizure of crypto asset related items. I did touch a minute ago on what I meant and what the definition is or will be in terms of a crypto asset related item. But looking at this particular section, the points that I will highlight is that law enforcement can require information which is stored in an electronic form and accessible for the premises to be produced in a form in a way which means it can be taken away and is viable and legible. So if individuals do not cooperate with this, then they can commit a further criminal offence.
The problem with that is that this is in the magistrate's court. So actually going through the contempt of court proceedings could be quite difficult. That doesn't seem to have been thought out to me. Is that something you're concerned about, or?
I think it is a useful tool for law enforcement. If someone is in their property and unwilling to hand over certain items, then I think it's a tool that can be used to maybe strengthen the argument that that item should be handed over. I agree with you in terms of the paperwork and going to magistrate's court. That is a very it's an interesting extra step, which I don't know how much will actually be used in practice.
Or how that will evolve depending on how the legislation goes. But no, it's certainly good.
Absolutely. So following on from that, officers can't require a person to produce privileged information. The bill defines privileged information as something a person would be entitled to refuse to provide. And currently there's no explanatory notes on that. It's an open-ended discussion. I don't think anything has really come to light at the moment and exactly what that might be. I suppose that's why it's still a bill. We're still working through that and trying to come to the bottom of what that might be.
I'd expect that there would be also for litigation privilege. So if you're looking at hard drives, a lot of hard drives will have some privileged information in it, as you both explained. It's very easy to hide passwords. So hiding passwords in places where there's litigation documents might be seen as a good idea. And then we might see the use of IP counsel similar to provisions in civil jurisdictions and the provisions in criminal jurisdictions. But I'd expect some regulatory notes on that. Well, I hope there will be some notes.
I think so, otherwise it might cause some problems. In terms of the seizure itself of the crypto-related item, it's to identify or gain access to a crypto wallet, and by doing so, enabling or facilitating the seizure. The section itself, as it says on the slide, it follows the spirit of the account freezing and forfeiture order regime under POCA in relation to the detention of cash. It's something we've already seen working in practice, and therefore it's hoped that in relation to the seizure of crypto asset related items, it will be as successful. In terms of timeframes, initial seizure is for 48 hours. This can be extended by 6 months, then another 6 months, so up to a period of 2 years, and then can it be extended even further? There are various extra provisions and pieces of the bill that I won't go into in relation to that. But in relation to any sort of civil forfeiture work, there are timescales involved, which everyone will need to bear in mind.
And especially with that, that's the extra year, if memory serves, is to allow international investigations, because that's been quite a big problem with AFOs. I just dealt with 8 million from Brazil, and we were quite close to the time limits on quite a lot of LORs. So it's interesting that they've included that in this one.
Yeah, I agree. I think sometimes in relation to investigations, particularly overseas, we're dealing with a piece of potential legislation here which is extremely complex and doesn't necessarily sit well in other jurisdictions. And therefore, bearing that in mind, I think an extra year in which to maybe process some of this is required in circumstances.
Should we move to the next slide?
Yes. In terms of seizure of crypto assets themselves, again, to seize crypto assets, there must be reasonable grounds for suspicion, for suspecting that the crypto assets are recoverable property or intended for use of unlawful conduct.
There we'll see the same case law we've seen at both cash seizures and account freezing orders, a similar test to arrest in essence.
Absolutely. Seizure includes circumstances where crypto assets are transferred into a crypto wallet controlled by a law enforcement officer. The section follows again the spirit of the AFO regime under POCA in relation to the detention of cash, and similar in terms of the timeframes. In terms of the timeframes themselves and the extensions, this is also the same for the seizure of the crypto asset related items. The extensions can be done by HMRC, a police constable, the serious fraud office, or an accredited financial investigator.
And the key bit there is the accredited financial investigator, because we see accredited financial investigators with a wide variety of agencies, from local authorities through to people who work for semi-private organisations such as the Royal Mail. So it does have a very wide scope to it,
yeah.
Which, and as we've seen with the account freezing orders. So go on to the next slide.
Yes. Okay, so the next section is in relation to safekeeping and release of crypto assets and related items. It's split into two here. 303Z33, what a wonderful way of describing a subsection, covers safekeeping, and Z34 covers release of the crypto assets and crypto related items. So this is where the magistrates can come into play. They can release whole or part of the property if the conditions for the detention of the property are no longer met, according to the magistrates.
So that will operate in a variation application where, as we've seen in 303Z4, an interested party can make an application. Is that correct?
Yes. Yes, they can make an application, very similar to Part 10A in the confiscation under Part 2 of POCA, in exactly the same sort of way.
This is a way where when the seizures are in place for a party to assert an interest, maybe even to try a discharge, if you're being very proactive responding to counsel, which I have been accused of. Proactive is the politest way it's ever been.
Yes, I have my own feelings on these sorts of arguments being had in the magistrates' court. And I'm sure when we move on to the issues that we may face with the potential bill, that probably is a point on there in relation to the fact that some of these applications are on the majority going to be made in front of lay magistrates with a legal advisor present. But moving on from that and carrying on with this particular slide, the release can be made on application from the person who the property was seized. And it can be released by those with control of the seizure. So whoever is in control of the seizure of the crypto assets, they are the ones who will then be asked by the magistrates to release them. There are provisions within this section in relation to crypto assets, which have been released but not claimed as well, which I think is a really great addition to the bill. Because it's something that could easily have been forgotten about.
Yes.
I think it's important that that's been picked up on. So after 1 year of its release, an officer may retain and deal with it as they see fit. So it's very wide in terms of what can be done with those crypto assets. So they could dispose of the item or destroy it, as long as they have informed the appropriate person. When I say appropriate person, I mean the person who the item has initially been seized from, or potentially someone who has made an application to state that they have an interest in the asset, which was not successful.
So with that, I imagine that all you need is to serve a document on the last known address of that person, similar to account freezing orders. So in that, you could have a situation where 3 million is in crypto assets is seized, somebody doesn't want to hang around to give an explanation for maybe obvious, maybe non-obvious reasons, and then even if you release them because the investigation doesn't go anywhere, my understanding is that this allows you to seize it, is that correct? Or do with it literally seize it?
Yes, so as it's described in explanatory notes, it is do as they see fit. With any kind of asset in the confiscation regime which is seized and obtained by law enforcement, it can go into the big UK PLC pot. So if it isn't disposed of and returned back to where it's supposed to be on release, it can go back into the fund.
I imagine that's where it would all go.
I imagine it may do, if it's worth the paper it's written on.
Yes. So no, that's a very interesting. Is there anything more you wanted to say on that?
No,
Right.
yeah, that's it on that side, thank you.
Well, let's move over to what happens after the investigation concludes. So the investigation under either of the 3 different areas is concluded, and the officer has decided that there is enough evidence at that stage to go for a freezing order. Yeah.
Yes, in terms of the freezing orders themselves.
Sorry, we can just go to the next
Yes,
slide.
sorry.
I apologize. That was my lack of coordination. I am the silver black of the host today, and I should be calling down the slides. So I do apologize.
Thanks, Ted. So,
That is fine.
yeah, cheers. So obviously just dealing with obviously the forfeiture provisions, the test is in essence exactly the same as those for account freezing orders. So whether it's recoverable property or intended for use in unlawful conduct. So that's been mirrored across that. And in the same way, there is discretion with the magistrates to forfeit some or all of the assets. As in the same way as with cash and account balances, as we've seen. And of course, in the same way, there are provisions that allow for reasonable legal expenses to be paid, but with what's found in 303Z41, which is what deals with the forfeiture order itself, there's a provision which allows at that stage, when the forfeiture order is being made, for legal expenses to be assessed and paid out at that point, which is something a little bit different in terms of the AFOs, because AFOs, obviously, there are variations and those are made throughout the proceedings, but they're not normally dealt with at the same time as the forfeiture order itself is made.
No, and I think one of the differences here is because you have three different types of freezing order and going to one forfeiture order.
Yeah.
Whereas there is much more of a linear approach. I did actually recently have a forfeiture order where they did order that at the end for your prosecution legal expenses. But that is an interesting, that's more of an evolution of the interpretation.
Yes, it seems like there have been sort of things happening in the magistrates' courts with variations and sort of allowing for those provisions and expenses to be made. And this seems to be sort of formalising that in some sense, putting it in the same way that we've seen with other aspects of that have already been touched on.
But as you said, this is fundamentally the same type of test as we see in forfeiture order.
Yeah.
So applying the same legislation, going back to civil recovery like Angus, etc.
Yes, and I think we can probably expect to see the same sort of case law in the same way that when the account freezing orders came in, the case law in terms of cash detention obviously mirrored over into account freezing orders. And so I think it's then going to jump through and apply in this sense, in the same sort of fashion.
One of the things I'm quite interested in, and this is because I'm a POCA geek, as most people know, is how in use is going to be the second limit is going to be seen, because I imagine with cryptocurrency, we're going to see much more cryptocurrency being used for criminal activities. Talk about it being used to buy things in the dark web, etc. And I imagine Sandu and Fletcher, the two cases, and that will be expanded for. But that might be something we get into next. So let's go to the next slide.
Well, I think we're still doing
I'm sorry.
a few minutes. Sorry. Tess, we could just go back. Sorry. Thanks. So in terms of other aspects that's on the slide, there's realisation and destruction options available as well within those provisions. And obviously, given the fluctuating nature of crypto assets, I think there's a lot of focus in the provisions for realising the assets to maximise the value of them. And we can see that touched on at several points in the bill and in the legislation that's proposed, which sort of puts on a duty to the enforcement authority, the person making the application, to ensure that the value is maximised.
That's going to be quite interesting with how that actually acts in practice. And also it puts quite a lot of focus on law enforcement agency to get the right amount of money. Is there still compensation provisions?
There are compensation provisions that are built into the legislation as well. And I think also in terms of the maximising value, when we get on to or just touching on the associated property provisions, within that, it allows for people to come forward and apply to the court if they have an interest in the property. But there's also provisions in there for them to be compensated and for any payments which are ultimately made to the enforcement authority to be lowered if there's any loss that they've incurred through the seizure and the freezing of the assets. And I think that's where the maximising the value could come into play, because if there's been any issues with or any arguments to say that the value hasn't been maximised at any point, I think that's where there could be arguments being made that there's going to be loss incurred, just because obviously given the fluctuating nature of the assets. So I think it does put some more sort of emphasis on enforcement authorities to be aware of, when is the best time. It gives them sort of an extra thing they're going to have to consider as part of the applications.
And that's another area of training where we've talked about identifying assets, but actually dealing with them management. There is some management firms out there which we can discuss, and some of those which we've worked with on previous seminars. But actually using them, identifying those services early is going to be a problem, I think, for law enforcement.
Yes, and then in terms of you'll see on the slides provisions dealing with associated and joint property in terms of, as I just mentioned, people having interests in the property. They can make an application, and if it's agreed, it can be dealt with in the magistrate's court. But if it's not agreed, then there are provisions to then transfer the case up to the High Court. So then we see it sort of becoming sort of akin to recovery proceedings, which is where we've, I think, traditionally up until this point seen sort of crypto issues being dealt with in sort of property freezing orders and so forth. So there are also provisions to take it out of the magistrates' court arena if there's going to be dispute as to interests.
And is that a dispute from third parties as who's got an interest? Or how wide is that test?
I think it's quite wide in terms of third parties who are saying that they have an interest, either at the time of seizure or just before, with crypto assets or the crypto wallet in question. There's no sort of real narrowing down from what I can see. So I think it can be quite, or I think it potentially could be quite wide. I think it's just going to be a case of how can you show, or, you know, to what extent can you show your interest?
But also tactically, it's going to be quite interesting how you frame your challenge to the order. And if you want to be able to push it up to the High Court, because as we talked about, the venue at the moment, the lay magistrates or district judges, having seen them dealing with 8 million, I think the biggest case I was involved is a couple of 100 million in a magistrates court is quite interesting. So we certainly see that how that develops.
Yes, and then just lastly, the provisions of victims having rights, and again, this provides a formal arrangement. I think as Barnaby touched on earlier, sort of formalising arrangements that we may have seen in the magistrates' courts to allow victims to be compensated if they are saying that the assets were theirs previously. And I think that's probably going to be very useful for law enforcement in terms of any overlapping criminal investigations or prosecutions. Because in my experience dealing with cases that I've been involved in, I know that authorities are very keen to maximise, obviously, compensation to victims. And often, if there's confiscation involved and so forth, it's a case of what is the best arena or what is the best avenue to be able to compensate as many people as sort of effectively as possible. So I think this, again, just gives another avenue, although it does put the emphasis on the person themselves to make the application rather than the authority doing it themselves, which does sort of give an extra dynamic, I think, to applications.
It does. It also could potentially echo or trumpet a movement away from confiscation and prosecutions given the backlog to these types of orders, because one of the issues has always been compensation, as you mentioned.
Yes, I think, could we have the next slide, thank you, Tess. And again, as already touched on, there are provisions in the legislation or the bill proposed to deal with maximising the value of the crypto assets, given obviously the fluctuating nature of them. And both the enforcement authority and the person from whom the assets were seized can apply for conversion of the assets. And again, there's that requirement in there to maximise or obtain the greatest value, in essence, sort of so far as it is practicable, is the wording used. And costs to do that may be deducted, although they have to be reasonable. And once that has been done, there's obviously requirements in terms of money being paid into interest-bearing accounts, and also the court has to have regard for, as part of the test for whether they're going to make this order, one of the circumstances they have to look at is whether the crypto assets are going to lose value significantly. And I think that's going to be interesting to see how magistrates courts deal with that, and how, because obviously they're not the experts in the value of crypto assets, the value of crypto wallets. So it's going to be interesting to see what evidence is put before them in terms of determining when the best time to realise the assets is.
But also, there seems to be quite a limited pool of experts.
Indeed.
So is this an area that How would you see that going down from your experience?
So we do it in a variety of different contexts. I was having a conversation with someone in our firm earlier, in our luxury asset division, buying and selling significant assets using crypto for the purchase. You are buying, say, for example, a yacht. And as we know, you can transfer crypto and it can be valued at the moment of transfer. It could go up or down significantly, and that's the volatile nature, of course, of these kind of assets. So we spend a long time speaking to a variety of third parties to effectively give us a window, a 30-minute window to allow us to convert at a set price, effectively fix it at that particular point, if the client wants it to be fixed back to a fiat currency. But trying to find people that have A, the requisite experience, and B, the requisite knowledge, and I suppose thirdly, the requisite insurance policies is even more important to place a value and to hold it. You mentioned some of the agencies that you've worked with. We act with a number of third parties who can potentially just provide that one-stop storage solution for us. Effectively, they will hold it, they'll store it, and they'll transfer it to whichever wallet it is that is supposed to after the transaction has taken place.
I think it will put a lot of pressure on judges, and this might see also a movement, this is a topic for a different seminar, to a more asset recovery based type of court, or even judges who have asset recovery tickets, like extradition.
Yes, no, I agree, because at the moment, I think recently, particularly during the pandemic, we saw a lot of movement of where cases were being dealt with in terms of cash detention and account freezing or forfeiture, sort of dotted around a few courts. Some were dealing with admin, some were dealing with this standard hearings. And so there was no real base for that these sorts of applications to be heard. But yes, hopefully, given the specialised nature of it, it's going to require specialised sort of courts, or as you say, ticketed judges. Otherwise, there's going to be a real mix of approaches.
Indeed. So on this, the other point is that no appeals are allowed.
No.
So there would have to be a judicial review, which would be interesting. And I imagine you will get judicial reviews, as you have on a variety of different subjects in cash forfeitures. Quite a few of those on our own Andrew Boden-Brown.
Yes.
Yes,
particularly if there's not going to be this specialised sort of, or judges or magistrates that are familiar with this. I think you're going to have a lot of reviews of decisions potentially.
Given how much money is at how many assets are at stake, and those assets will continue to change. So should we just move on to the broader themes? And I see we're already starting to get some questions. So now we're just going to round up, and we've got about 10 to 15 minutes left. So please, hopefully about 10 minutes. So if you do have any questions, please do put them in the Q&A rather than in the chat. So put it in the Q&A, I'll have a look through it, and then I'll ask the panel. So, going to potential pitfalls, everybody. We've seen the technology is evolving quickly, Andrew, as you've highlighted. Do you see that as the biggest problem in the definitions, or do you see that affecting legislation in any other way?
I think it's the application of the legislation for the circumstance that we find ourselves in. So understanding the technology, trying to differentiate it from how potentially it's being applied in different circumstances, I think is the difficult thing. But as with most things, we have to continue to keep abreast of the developments ourselves to try and understand what's coming down the line. New technologies are being developed quicker than we can potentially keep up with some of these, and therefore educating both ourselves and, as I say, the judiciary, I think for me is the biggest problem, and identifying the right experts, the right barristers, the right lawyers to be able to present that in a way that makes it easy for a judge to make a determination.
Lauren, where do you see the biggest problem with this legislation? Or biggest strength?
Well, actually, something which hasn't really been picked up on yet. We're talking about, how quickly this is all evolving, and the powers could become outdated. But in fact, there is provision within the definitions of crypto assets and crypto wallet for them to be amended. So, although there is
and amended by statutory instrument rather than But by legislation, yes, indeed.
Exactly. So looking at that, it just makes, it allows the legislation to expand where needed. And that's nice to see. So although we're talking about pitfalls here, I just thought I'd pick up on that particular point. In terms of the general problems that we face, the standard of proof is quite low in terms of when you can seize. The civil standard is a lower burden than the criminal standard, and therefore it makes it, I will use these words wisely, easier for law enforcement to seize crypto assets and crypto-related items. Bearing that in mind, it makes it difficult for the defence and defence practitioners. And as a practicing defence practitioner, that is something which needs to be considered. And it is hoped that the powers which are being given to law enforcement are used wisely. And I'm hoping that seminars like this help with the education on those particular points.
Going on to that, one of my concerns is reasonable suspicion and cryptocurrency. There's a widespread view that cryptocurrency is automatically a reasonable suspicion ground. Having worked in the area for a long time, as all of us have, that's wrong. But there is an education issue here. And I think that's what you both highlighted. We've seen a regular instance. Cryptocurrency has been around in proper proceedings since at least 2015. And having an education and making sure that tribunals and courts and tribunals are educated about this is going to be important. And also, as always with investigators, I'm sure they will, making sure that there is real evidence there, rather than just saying cryptocurrency equals seizure. The other problem with that is the compensation provisions could be quite scary, because if there's a mistake made with the conversion of cryptocurrency, we've seen how quickly cryptocurrency moves. That could be £4 or £5 million worth of compensation. Compensation is rare in these proceedings, but I think with cryptocurrency that might be an issue. That's my general concern. What about yours?
No, I think I'd agree in terms of there's still a lot of mystery, I think, around cryptocurrency. But again, as you say, it's down to sort of a lack of education and understanding on it. So I think it's going to be interesting to see whether there is the use of experts in these proceedings and so forth. Because obviously we've already touched on the rarity perhaps of those experts and whether and how they can be deployed in the courts to explain some of these aspects. Because of course, as counsel and defence representatives, we can put forth arguments to the court and try and explain in that sense, but we're obviously not technically experts in the field, and so it's going to be interesting to see how what the evidence is in essence, what sort of form that takes when it's being put before the court to try and lower that mystique, I suppose, and make it accessible for magistrates, district judges.
No, it's not necessarily a pitfall, but for me, the most exciting feature of the legislation is that it provides another alternative route for victims. At the moment, victims, they have very limited options. They can contact action fraud, and it may or may not be the case that results in something. Civil proceedings are expensive. I'm not going to hide from that. And a lot of that, of course, is because it's urgent, because we're seeking various different types of injunctions. We're seeking disclosure orders, we're seeking proprietary injunctions, worldwide freezing orders. So for victims to have another option, I think is great. What it does mean, unfortunately, I think is the courts are going to be flooded with, or the police, certainly law enforcement, are going to be flooded with victims. We don't have a shortage of potential cases. What we have is a shortage of individuals who unfortunately have the resources to be able to pursue the recovery. So therefore, to have someone who has lost, for example, less than £50,000 in terms of monetary value, and to have an alternative remedy outside of the traditional civil proceedings is fantastic, because unfortunately, finding sufficient resource to be able to fund the civil recovery matter at the moment is difficult. We have good relationships with a number of litigation funders to be able to help victims, but it's always difficult when they've already lost a lot of money to try and reach into their pockets and go again.
Well, this goes into two of the issues which are interrelated, which I was going to highlight, is the funding for investigators in this area. I don't think the agencies are going to be prepared for how much is going to be needed. It could be solved by ARIS if the money is actually funneled back in, because it will make a lot of money, as we've seen with AFOs. But especially with the victim issue, it is going to become a very good and efficient way to deal with this, if it works.
Yes.
But that is the numbers issue. And then guidance on how you do, which cases do you prioritise.
Yep.
The other area is going to always be how multi-agencies deal with matters and who has priority. But I don't think there's a silver bullet there either. Now, we've had a couple of questions that I'm just going to quickly go through. Raymond's asked about the difficulties of movement of crypto assets, and because they can move quickly, as can accounts. How easy is it in your experience to be able to seize them, because they can just move at a blink of an eye?
Absolutely. The nature of the asset that we're dealing with is highly fluid. It can move very, very quickly between exchanges, between mixers, tumblers. So, in that particular scenario, it unfortunately becomes a good old-fashioned tracing exercise, to the extent that we have to follow the hops, relying upon the evidence or the information provided to us by our experts. And that, unfortunately, in the civil context, is where a lot of the cost comes in. If there has been a delay in us being instructed, we are trying to catch up with something that could have been moved thousands of times in a week, in a month. We have people contacting us saying that they were the victim of fraud 6 months ago. Unfortunately, in those circumstances, it is very, very difficult to locate it. So if we can, speed and timing is of the essence.
Now, then, just going on to Emma's question. She's asked again about the issue that we discussed, which is realizing of assets, and how does an investigator maximize that? My answer would be, well, that's where experts come in and getting consultant services. And I think you'll see the rise of using consultants to advise on that, but also consultants with the right insurance.
Yes, I agree, because obviously we can all have expertise in terms of the legislation in this area, but in terms of the markets themselves, it's a whole different ballgame. And obviously, as has been highlighted with them, we're gambling someone else's money here and the value of the asset. And so in terms of being practitioners ourselves, we would want to have some assurance that we're doing everything to maximise that and to ensure that we're not exposing anyone to any risk. So I think in that sense, as you say, Barnaby, that expert or consultants are going to be more prevalent.
Indeed, I'm becoming quite protective of the names of my crypto consultants already. I don't know if I want to share them. The last question from Neville was about bringing the example of him being a local authority investigator, financial investigator, not having much experience or not using cash seizure powers much or account freezing powers much, but then still having the powers to do these types of seizures. And I think that's one of the big issues, is lack of experience, because as we said, training is going to be key here. I don't want to plug that Fighting Andrews here has one of the leading asset recovery practices, and we're always happy to help along with various other firms and experts. But that is where bringing in experts is going to be key, in my view, throughout. So now we've got to almost bang on 6:30, and we will, Tess will ask us to stop now. So one quick thought from everybody. I've spoken enough. Gemma.
Well, I just think it's good to see something sort of being formalised, so that we're all going to have a clear sort of way forward in terms of the arenas and where these issues are going to be dealt with. And it's just be interesting to see how that develops, particularly given, as we know, the changing and very varied nature that can be the magistrates' court.
Indeed. At least there is a High Court path, but if that will be used.
I suppose what I would say is that I'm pleased to see tried and tested methods in other areas of civil recovery being copy and pasted really into the new legislation. For me, that actually gives comfort for once, because it's rare where I see a bill or a new piece of legislation where I think that will work. It's great to see that here. I think it's a well thought out piece of legislation, which I'm pleased to see.
And is also using tried and tested types of legislation, which we have case law on and works. And to Liam's last question, no, I don't think it's been influenced particularly by sanctions. This is an approach which has been in the works for a couple of years, and it's using tried and tested principles, as we mentioned. Andrew, what's your last thoughts?
I touched on victims. For me, I deal with lots of victims on a regular basis. To have an alternative to the traditional civil procedure recovery options is a real advantage. I'm excited to see civil procedure being played out in a criminal style court, to see how that occurs. But genuinely excited that we seem to be trying to lead in an area that is the future, regardless of whether we may like it or not.
Well, on that note, and just over time, but close enough, thank you everybody for your contributions.
Thank you.
And thank you everybody for attending. This will be up on YouTube, on our YouTube channel, shortly, I imagine in the next week. And other information, including the slides, will also be available. Thank you, everybody, and thank you for attending.